I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are stepping into number 161 on our compilation list. We will be in 3 different judges' courtrooms. Whatever you guys do, please don't forget to like, comment, share, and subscribe. Especially subscribe if you're going to be watching these videos on a regular, because many of our viewers are not subscribers. So if you can smash that subscribe button, it will be a blessing to us. Also, there will be commentary left in this compilation from these previous proceedings. Chapters will be added for your convenience. And now let me give you the rundown of the judges for 161. First, we will be in the courtroom of Judge Jeffrey Gettler out of the state of Kansas. And shout out to Sovereign Citizen Chronicles for sharing this particular video with me. Second, I have a treat for you, a non-SOVCIT case that will be in the courtroom of Judge Lydia Bryant out of the state of Michigan. Very popular judge, no nonsense. And last but not least, our third proceeding will be coming out of the courtroom of Judge David Robinson, also in the state of Michigan. Guys, as always, thank you for joining me. And now let's go ahead and jump into 161.
We'll note the state appears by Assistant County Attorney Mr. Gayoso for these informal first appearances. Good morning. You are Shauna Nickel. You are Miss Nickel?
I'm sorry, no, I'm not.
You're Shauna Nickel?
No.
Oh. What's your first name?
I'm the living, breathing entity, the actual person that stands before you.
All right. So
I'm not the strong man on any paper, any all caps person by any means.
you don't have a name, a legal name?
Under certain charges, yes, under that, but under what would be the word? Under distress. Literally bringing me in here against my will. I mean, I didn't break any laws.
And you were brought in under the name Shauna Nickel?
No, I should not have been. No, I was not. No, they decided what my name was before they ever ripped me out of the vehicle. They called me a name before I was ever able to give them a name. But I am the breathing, living entity before you here. I'm not that person on that piece of paper.
Okay, and does this living, breathing entity before me have a name?
My mother calls me daughter. My father calls me daughter. My children call me mother.
What is your legal name that you were given at birth?
That's straw man. I'm sorry, I can't answer that question. I'm just not answering any more questions. I haven't had the chance for a phone call, attorney, nothing. So I'm not going to answer. I can't answer any more questions.
All right, Deputy, based on your information, is that Shauna D. Nickel?
Yes, Your Honor.
All right. Ms. Nickel, you are appearing before me, having been arrested in a couple matters. One is MGI 24 CR 193. That was an arrest warrant. That was issued as a result of the state filing complaint information wherein you are charged with the following 5 counts. Count 1 is identity theft. It alleges on or about March 13, 2024 in Montgomery County, Kansas, that you unlawfully and feloniously used any personal identifying information or document containing the same belonging to or issued to another person, to it, Sherry D. Dodge, with the intent to defraud that person or anyone else, to it, Deputy Steve Gass, in order to receive any benefit. Identity theft as charged here is a level 8 non-person felony. It carries a sentencing range of 7 to 23 months in prison, a fine up to $100,000, and 12 months post-release supervision. Counts 2, 3, 4, and 5 are also alleged to have occurred on or about March 13, 2024 in Montgomery County, Kansas. Count 2 is interference with law enforcement. It alleges that you unlawfully and knowingly obstructed, resisted, or opposed a person authorized by law to serve process, to it, Steve Gass, in the discharge of any official duty. To it, provided false information regarding the name and date of birth. That's a Class A non-person misdemeanor, carries a penalty of up to 1 year in the county jail and or fine up to $2,500. And count 3, you're charged with driving while suspended, second offense. It is alleged that you unlawfully operated a motor vehicle on a highway of this state at a time when your privilege to do so was canceled, suspended, or revoked, and that you had previously been convicted of a violation of this section or any ordinance of any city, resolution of any county, or a law of another state that prohibits the acts prohibited by those statutes. Driving while suspended, second offense, is a let's see, carries a penalty of 5 days to a maximum of 12 months in jail, a minimum fine of $100 up to $2,500. In count 4, you are charged with no proof of insurance. It is alleged that you unlawfully operated a motor vehicle upon a highway or upon property open to use by the public and failed to display, upon demand, evidence of financial security to a law enforcement officer, having been lawfully requested to do so in accordance with provisions of the Automobile Injury Reparations Act. That's a Class B non-person misdemeanor, carries a penalty of up to 6 months in the county jail, and or a minimum fine of $300 up to $1,000. And in count 5, you're charged with illegal registration. It is alleged that you unlawfully displayed or caused, permitted to be displayed, or had in your possession any registration receipt, certificate of title, registration license plate, registration decal, accessible parking placard, or accessible parking identification card, knowing the same to be fictitious or to have been canceled, revoked, suspended, or altered. That is an unclassified misdemeanor, carries a penalty of a fine not exceeding $2,500 or imprisonment in the county jail for not less than 30 days, nor more than 6 months, or both such fine and imprisonment. So those are your charges and possible penalties in MGI 24 CR 193, for which you were arrested on that warrant. You were also arrested on probable cause, that being out by the Montgomery County Sheriff's Office, their case number 25-1459, and that was for the offenses of possession of methamphetamine, possession of drug paraphernalia, interference with law enforcement, and transporting open container. That occurring allegedly on or about December 16 of 2025 in Montgomery County, Kansas. I have found probable cause to support your arrest for that offense. Mr. Gaoso, I have a pre-sentence investigation report for Ms. Nickel from a 2014 case, 14 CR 153. At that time, she had a, criminal history score of H and had a number of traffic infractions, domestic battery, marijuana, disorderly conduct, some DUIs, things of that nature. Do you have any more recent criminal history for Ms. Nickel?
I do not, Your Honor.
And the arrest warrant that was issued for 24 CR 193, I included a cash surety bond of $5,000. I didn't require supervision for that, but in light of Ms. Nichols' remarks here this morning, I'm more concerned with her risk of flight. And so I'm inclined to modify the bond and to address a bond to cover this new case as well. So what is the state's bond recommendation?
Your Honor, we would request a $7,500 cash or professional surety bond for both cases, and we would also request bond supervision.
All right. So Ms. Nickel, your bond to cover both matters is going to be $7,500. Cash or professional surety with supervision. What that means is for you to get out of jail, you either need to post $7,500 to the clerk of the court, or you can go through a bondsman. If you go through a bondsman, you pay them no less than 10% of that amount. That'd be $750. Could be more, but would not be less. The supervision component means if you do make that bond, you need to immediately report to court services upon your release from jail. They're located next door in the old Montgomery County Courthouse, the building immediately to the west of this one. Your failure to report to them upon your release from jail and anytime thereafter they direct would be a violation of your bond. It could result in being revoked, and you find yourself back in custody. Any questions about that, Ms. Nickel?
No.
Do you intend on hiring your own attorney? Do you want the court to consider appointing you one?
I'm not sure.
Well, the devil's going to give you an application and affidavit. So in the event you decide you want the court to consider appointing you one, fill that paperwork out and return it. And if you qualify financially, I'll be more than happy to appoint you an attorney. But should you choose to hire your own, or if you don't qualify financially, then you'll have to do that as well. I would note you're to have no contact of any kind, direct or indirect, with Sherry Dodge, who is alleged non-law enforcement victim in 24 CR 193. And you're to have no contact of any kind, direct or indirect, with William Schuyler, to whom you were arrested with in the unfiled Montgomery County Sheriff's Office case. If you're to have contact with either of those individuals, directly or indirectly, in any way, shape, or form, that would be a violation of your bond, and it could result in being revoked, and you find yourself back in jail. Any questions about that?
No.
All right. Your next court date, and I showed this, Mr. Gao, so the 24 CR 193 is a north half case. This unfiled case is a south half case. So when would you like these put on the docket, on north or south half?
Your Honor, if you don't mind, just because I believe that you are the assigned judge for the 24 CR 193 case.
I am, correct.
I don't have an issue in just both cases being assigned to the south half case, if that is okay with the court.
All right. So the next court date in just so there's no confusion for you, Miss Nickel. Let's see. There's no court next Thursday. Mr. Goso, do you think the charges are going to be on file by the 23rd in this new case?
I believe that is appropriate, Your Honor. I know that a complaint has already been prepared, and in speaking with our office, we hope to have it on file this afternoon or tomorrow. So,
all right. So, Miss Nickel, I'm going to set both your cases for hearing on Tuesday, December 23rd at 9 o'clock by Zoom. If you have bonded out and you're not in jail on that date, you either need to make yourself available by Zoom by getting signed on your own with your own device and your own internet connection. Or if you don't want to do that or can't do that, you need to come back here to the Judicial Center, check in at the clerk's window by 9 a.m. on Tuesday, December 23rd. And when your case is called, they'll get you set up on a laptop to participate in that hearing. On that date, you'll find out what you've been formally charged with in this unfiled case. Thereafter, both your cases will be set on my next docket, January 15th at 9 o'clock. And that will be the instructions that will be given to the judge on that day. So for now, you just need to make yourself available to be in court Tuesday, December 23rd at 9 o'clock. If you're still in jail on that day, you'll appear by Zoom from the jail like you did today. Again, if you do bond out, be sure to, one, check in with court services upon your release, and then make yourself available by Zoom on the 23rd, or come here and use our laptop on the 23rd. Any questions about any of that, Ms. Nickel?
I don't think so.
All right. Thank you for your time. You're free to go today.
All right, I'm ready on Shabazz. No, I'm sorry, Tripp. I'll do Tripp first, because did you tell me Tripp was ready earlier?
Yes, Your Honor.
I'm ready on Tripp. And what are we doing on Watson Wilson? Am I coming down for a trial?
We have a resolution, Your Honor, PTR. We're in receipt of what we want.
Okay, this is case number 244438701. The People versus Christopher. Might be Lorenzo is cut off on the docket. Tripp, defendant, is charged with child abuse, 4th degree. Today is the date set for final pretrial conference appearances, please.
Morning, Your Honor. Alex Hill on behalf of the people.
Here, Mr. Tripp will continue. Dennis Stevenson on behalf of Christopher Tripp. Mr. Tripp, please say your first, middle, and last names.
Christopher Lorenzo Tripp.
All right, Ms. Stevenson, how are you proceeding? Because you was getting ready to tell us.
Right. Mr. Tripp is going to continue his plea of not guilty, but I would ask for sidebar with the court and the people.
Right now?
If I'm
This might help.
So that means you all want me to come downstairs because Mr. Hill is not on this thing?
But he and Miss Coleman, they'd come in here or something.
Okay.
Okay, thank you, Your Honor. We're gonna go into the room right now.
All right, come into the room.
Thank you guys. Thank you for your patience.
Then I guess we need to go to breakout. Wouldn't it be funny if we just started talking right here? Join me in breakout room number 1.
You just have to see something.
All right, back on the record with the people versus Christopher Tripp.
No. Oh, I got
Man, I'm only gonna let you talk to him for about another minute.
Okay, Your Honor, thank you very much for that, Grace. Trying to just figure out how Mr. Tripp can help the people to have a conversation with the complaining witness's mother.
Oh, well, I'm gonna tell you how we're gonna have a conversation with him. If she don't answer the phone the next time, if she doesn't respond to that text the next time, I'm gonna send the police out there. I'm gonna send the police to the child's school. And then we're going to take care, custody, and control over the child. And then they'll have to get the child from protective services. So let me be clear. Let me be clear out of my mouth. Let me be clear. If Mr. Tripp resides with the mother, then he better go home and tell her that she better answer Mr. Hill's phone call. She better respond to his text, and she better produce my witness, because failure to do so is going to cause me to show cause her, and I'm going to have her arrested. Listen to me clearly and carefully. I'm going to have her arrested, and I'm talking about the mother of the child. Whoever has care, custody, and control over the child, they had better produce the child to Mr. Hill. They had better produce the child to Mr. Hill. Stop talking. Stop talking. Whoever has care, custody, and control of the minor witness had better produce the witness to Mr. Hill. Failure to do so is going to result in me contacting protective services, in me issuing an arrest warrant for interference with this criminal prosecution. It is going to result in charges for witness tampering. Listen to me carefully and clear. I'm not playing. Now, the case can be resolved, and I will entertain pretrial resolutions, which will include in-person classes. But what I will not do is allow some person to bully this court system. It's never going to happen. The bullying of this court system, it's never going to happen. So whoever has the child, I know the baby got a cell phone. It's 2025. But what I also know is that she's in school. She's in school. Either she being homeschooled, and that address has to be registered with the state, or she's in a physical school. And she's going to talk to Mr. Hill. The witness is going to talk to Mr. Hill. And if the mother has custody, they're going to produce the child. If Mr. Tripp has custody, he's going to produce the child. Whoever fails or refuses to produce the child, I'm going to have those charges issued against them. And we're going to have a warrant for their arrest. All right. Now, any further facilitation, that's y'all business. If Mr. Hill comes back here and tell me that they still not answering his calls, he can't find his witness, this minor witness, it's going to be somebody is going to have to deal with that, and they're going to have to deal with me. Anything else before I get a date?
Thank you, Your Honor. Nothing by the people further.
So for the date, Your Honor, in that we would have to be able to arrange the in-person classes.
Sound like the whole family needs some classes, but I can't make the other people go to class. Does Mr. Tripp work?
Not at this time, Your Honor.
Oh, well, then he could go to the classes. but I don't know where the in-person classes are. You know, I'd be thinking Mr. Rice can do anything. I feel like he has all the classes, but those may not be free, so I do understand that. I'm not opposed to it. Maybe you need to get a referral from probation,
Okay,
but yeah. And I am live streaming right now. So if you want to go back and play this for her, you can go back and play this for her. If you don't have if somebody don't have they don't want to say it with as much fervor as I'm saying it, the video is gonna be there. You just show her this is what the judge said. And I mean it from the complete bottom of my heart. I mean it. I mean it. I mean it because I feel like she's trying to bully the system and trying to whatever. And I'm not going to have it. I'm not going to have it. Okay. So let's do this. And I want at least 6 classes in order for me to accept the pretrial resolution. What I'm saying is, Trip, you can't listen to her, talk to her, and listen to me at the same time.
I just explained to her, I have seizures and right now I feel like I'm having a panic right now. I have medical issues for it.
Now, you're not gonna make me put you in the Wayne County Jail and mark your file medical.
No.
Okay, well, take a deep breath. We're gonna take a deep breath. If you need some water, they can give you some water. But let me say this to you. If you can take a deep breath. And if you need some water, they can give you some water. Because court is stressful. And if the stress is going to trigger whatever you're having, then we're going to need to get you some medical attention. All right. I'm going to set it for at least 6 weeks, 8 weeks out, because I want 6 classes in order for me to entertain the pretrial resolution.
okay.
So I could put it October 29th, but I won't. I will put it. Oh, I can't put it. Oh, I could put it. I think I could put it. Let me see what time I'm on. Might leave. I could put it November. Let me see. That might not work. That's 12/25. That means I could put it November the 3rd. Yeah, I'll put it November the 3rd. For final pretrial conference.
Thank you.
And then I'm going to go ahead and put it on my trial docket as well, November 3rd. And so then I'm going to put it on the trial docket for December 2nd. So let's put November 3rd at 9:10. And then I'm going to put it for a jury trial. December 2nd. And know that it is first in priority. That's why I put it on the 2nd to make sure. And that's at 9:30. So if the matter doesn't resolve, oh, I keep looking. This is Trip. And this is MFD. And that. All right. And then I want to have to lock nobody up while they wait in order to get the witness for the trial.
Do that. You gotta do that.
Anything further on behalf of the people,
No, Your Honor, thank you.
on behalf of the defense?
No, thank you, Your Honor.
All right, we're all set then. Everyone have a great day. Stay safe.
Thank you very much, Your Honor.
You're welcome.
We are on the record calling 2-1-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. No appearances.
Good morning, Your Honor. May it please the court, Suzanne Strickarts, P44018, on behalf of the plaintiff.
And your name, sir?
Kevin Hurst.
Okay, where are we on this file, people?
Your Honor, we had a pretrial. You opened up a written discovery. We did send discovery out. We did receive it back, apparently unopened, indicating there was a written on the envelope itself. It had written, I'm reading here, I do not accept your offer to contract, all rights reserved, UCC 1-308 signed, and then it was a return to sender, Judge.
All right,
So
Mr.
we attempted to do discovery anyways.
Mr. Hurst, did you refuse to accept the mail?
Did I refuse to accept the mail? Yes.
Sir, you can't do that.
I can refuse to accept any mail that comes to me.
This is what we're going to do. One of the things she sent you were requests for admissions. If you do not provide proper answers to those requests for admissions, they are deemed to be conclusively admitted. Do you understand that, sir?
Objection, Your Honor.
Do you understand what I have said?
No, I don't.
All right, here it is. I open written discovery in this matter. You have a right to whatever legal position you want, but you do not have your own set of court rules. Among the things that the court rules provide when written discovery is open is that she can send you requests for admissions. Those requests for admissions are in writing and they must be answered under oath and in a certain time frame. If they are not answered and filed in accord with the court rules, then they are deemed to be conclusively admitted. You will not be able to contest those things. And that was what was sent to you, sir. And that time to start running those started with the day they were mailed to you.
Your Honor.
You don't want to accept it.
I'm not even sure. I do not have any understanding of this is my debt or not. They just coming with these allegations. I'm trying to see and verify if it is. Then when they called me the first time, they should have sent out verified documents stating that the original creditor and who it was and that I truly owe this debt.
Well, Your Honor, I just indicate that we did attach to those.
They already,
Excuse me, Mr. Hurst.
Excuse me, I wasn't finished.
Excuse me.
I wasn't finished. I wasn't finished. She cut me off.
You, Mr. Hurst. I'm not going to have this.
Your Honor, she cut me off.
I'm not going to have this.
Talking.
This is not a clown show.
Oh my goodness.
One at a time.
I can finish my statement.
You will speak one. Don't interrupt me again, Mr. Hurst.
Go ahead, sir.
Why, thank you. You will speak one at a time. You will not interrupt each other. You will not interrupt me. Do you understand what I have said? Mr. Hurst.
I don't understand anything.
Okay, fine.
I don't even understand why I'm here.
I'm going to mute you.
I don't even understand what's going on.
I'm muting Mr. Hurst, and I will let Ms. Strickard say what it is she wishes to say. Then I will unmute Mr. Hurst and allow Mr. Hurst to speak. Ms. Strickard, you were responding, Mr. Hurst.
Yes, sure. I was just indicating that we did attach the account statements, the full chain of title and seller data sheet to the packet. So even though there was no requirement, we did want to provide that to the defendant. And so that was in all of those materials were in the packet that was rejected, Judge.
Well, let's let Mr. Hurst respond.
Okay, so the understanding that I have is that they should have contacted me 5 days after they should have gave me documents 5 days after they contacted me about the alleged debt. I told them I have no recollection of the debt. Yeah, I don't even know enough information to admit or deny the allegations to the debt. So if they're accusing me of this debt, I would like to ask them a few questions so that they can verify that this debt even belongs to me. And that's why I refused the packet, because I don't know if they're trying to contract with me or not. I didn't know what it was, so I sent it back.
All right, let me explain it to you again. Whatever political views you have.
I had no understanding that they were sending me these things. They didn't even tell me that they was going to send me. In the last court date, did they say, or did she say, we're going to send you something?
Sir, I opened written discovery. That allows you to serve written discovery. That allows her to serve written discovery. And she did so. If you elect not to receive it, then that's on you. That's the risk, and you bear the risk of that. But I would urge you, and let me tell you, as I told you at the beginning, you have an absolute constitutional right to represent yourself, but what you do not have is a right to your own set of court rules. You may not be frustrating the court rules, sir, by refusing to accept mail. If that's the choice you make, then that's the choice you make, and you will have to live with the consequences of that. I would urge you, sir, perhaps you might want to get counsel, because I don't think you understand the process, and I'm not at all sure you understand the consequences of the choices that you are making. However, as I indicated, you have an absolute constitutional right to represent yourself. I would urge you to get counsel. So I'm going to give you another date. And sir, she is going to do what she does to represent her client, and you're going to do what you do. And if the court rules cut against you, then so be it.
I got a question. They are claiming that this debt belonged to me. Would they have to produce all the proof and verify that this debt belongs to me?
The plaintiff has the burden of proof, Mr. Hurst.
That's right. So she had to produce the proof that this debt belongs to me, right?
She has the burden of proof.
Okay. Thank you.
All right.
Judge,
I'm sorry, Ms. Rickards?
Your Honor, would it be possible for us to receive a motion date for, say, mid-July?
Let's give him one more opportunity.
Oh, you want me to resend the packet, Judge?
I want you to resend the package. And sir, let me urge you as strongly as I can. So receive and open the package. Because if you do not, the request for admissions will be deemed to be conclusively admitted. The lawsuit, as a practical matter, will be over. Do you understand what I have said to you?
Yeah, I understand. Do you, I got a question. Should they have sent me something before they send me this package since the last court date?
Sir,
to verify that?
Sir, they're not required. If you think you need some information, you have the right to seek discovery too. But you can't tell them how to litigate their case.
Okay, so she's going to send me a packet and I'm going to send her back a packet as well, right?
No, you're going to do what you choose to do. She's going to send you again those requests for admissions.
Well, you said that
Don't interrupt me again. We had this conversation before, didn't we?
Sorry.
We had this conversation before.
Go ahead.
As a courtesy to you, she's going to send you the request for admissions one more time. You will either accept the package or you will not. You will answer and serve the request for admissions in accord with the Michigan court rules, or you will not. And then if you do not, then those things will be deemed to be conclusively admitted. If you choose to send written request for discovery, you have a right to do that too. You can send written interrogatories, request for production of documents, and request for admissions, same as her. All right, we are on the record. This is 21-170-598. Midland Credit Management versus Kevin Hurst. Date and time for pretrial. Your appearance.
Good morning, Your Honor. May it please the court, Suzanne Strickhartz, P44018, on behalf of the plaintiff.
And what is your name, sir?
Kevin Hurst.
Okay. All right.
I do hereby reserve all of my rights, waiving none, not to be compelled to perform under any contract or commercial agreement that I did not knowingly, voluntarily, or intentionally. I do not accept the liability of any compel benefit or unrevealed contract or commercial agreement without prejudice.
You're gonna wipe up all those crayons you just spit everywhere?
Is there anything else you want to say, Mr. Hurst?
That's it.
All right. All right, where are we on this file?
Judge, discovery's been completed. Motion for summary's been filed. We are looking for the court to assign a date.
Okay. Let's get you guys a date. Mr. Hurst, do you have the motion for summary disposition filed on behalf of the plaintiff?
It looks like this.
What's that?
It looks like this.
I'm asking
Okay, yeah.
you first if you received the motion for summary disposition filed by the plaintiff.
Do I have it?
Yes, sir.
Yes.
Okay. So let's set you a date for hearing and we'll move on. Does July 26th at 10 o'clock, does that work for everybody?
Yep.
Yes, Your Honor.
Okay. July 26th at 10 o'clock, we will hear the plaintiff's motion for summary disposition. Sir, if you wish to file and serve an answer to that motion for summary disposition, you must do so within the terms provided in the Michigan Court Rules. We'll hear the motion July 26th at 10 o'clock. Again, sir, if you want to file an answer, be sure to serve both the court and the counsel for the other side. All right, the court has had an opportunity to review the pleadings here. I was particularly interested in the request for admissions that was served by the defendant. Request for admission number 3. Does the plaintiff admit and have proof that the allegations against the respondent are true and accurate with all documentation being verified, signature and seals? These were admitted. Does number 4, does plaintiff admit and or have proof that the statute of limitations has not expired to collect on his alleged debt? Plaintiff admitted that. Does the plaintiff admit number 6 and have proof that the respondent had a meeting of the minds with Credit One Bank pursuant to the contract agreement in respect to full disclosure, and that said contract contains no elements of fraud by Credit One Bank? Plaintiff admits that. In number 7, does the plaintiff admit and have proof that Midland Credit Management purchased this contract from the original creditor and is now the new owner of the alleged contract and of the said debt that is owed? Plaintiff admitted that. So what we have is we have an admissions by our defendant of the validity of the contract, admission by a defendant that Midland creditor is a proper party plaintiff. And then we have in our request for admission number 8, does plaintiff admit and have proof that Credit One Bank did loan their credit to respondent and that the respondent is only obligated to pay back in money to Midland Credit Management? Plaintiff admitted that too. I also note for the record that having reviewed the brief answer to plaintiff's motion for summary disposition, first of all, contrary to the court rule, is not supported by an affidavit. 2.116 G4 says that when a motion for summary disposition under C10 has been filed and served, the opposing party here would be the defendant, may not rely upon his pleadings, but must by affidavit or as otherwise provided in this rule demonstrate the existence of genuine issue of material fact. Again, I note for the record, no affidavit was submitted here. I think it's fair to say that the pleading filed by the defendant is somewhat obtuse. I quote, for example, from the 3rd page, the agreed upon proof of claim does not serve in place of the original account, for it is a conditional acceptance and not the foundation of an action, and does not become an original demand and amount to an express promise to pay the actual sum stated. In his first paragraph, the plaintiff, and I'm quoting again, plaintiff claims that the living soul utilizes an address in his answer, when in fact the address that is used there indicates that the living soul does not live at this address, but is receiving mail there. So Defendant has failed to appear. He has failed to support his brief answer to plaintiff's motion for summary disposition by affidavit as required by the court rule. The court has had an opportunity to review the pleadings filed on behalf of the plaintiff in this matter, and I'm satisfied. There's no genuine issue of material fact in this matter. Summary disposition is granted in favor of the plaintiff. If you'd be kind enough to send me your judgment under the 7-day rule, I'd appreciate it. Well, guys, we have come to the end of another proceeding. And as we can see earlier on in this proceeding, Mr. Kevin Hurst truly rubbed Judge Robinson the wrong way, to the point of where Judge Robinson blurted out, "This is not a clown show. We're not having this. I'm not going to allow you to do this in my court. Whether we're on Zoom or whether you're in person, it doesn't matter. I'm not going to have this." And as we can see, Kevin Hurst, he wanted to represent himself, but did not even have enough understanding to receive the discovery packet. Instead, he refused it, thinking that he was benefiting himself when actually he was shooting himself in the foot. But let's give Judge Robinson credit, because later on he gives him an opportunity to receive the packet again when he did not have to, even though Mr. Hurst rubbed Judge Robinson the wrong way in so many different ways. We see where Mr. Hurst, he goes on this crazy rant about how the prosecutor cut him off. She's not allowing him to talk. But if you go back in the moment when he said that in that part of the proceeding, he actually has stopped talking. So just every which way he turned, he wasn't doing himself any type of favors. We see, just like in the Marcus Campbell situation, if you have not seen that, I don't want to spoil everything that went on in there, but they asked for a summary disposition and it was granted. And we went over a little bit of what a summary disposition was in the last case, and that is also known as a summary judgment, where it allows the judge to rule in the favor of one party without going, through a full trial if the other party didn't dispute the facts clearly and in the right manner. And as we can see in this situation, he definitely did not dispute anything that these lawyers that were representing these banks had to say. So with that being said, guys, I know you guys are ready to get out of here and do what you got to do. I know you're anxious for the next proceeding, and God willing, Lord willing, we will have another one for you tomorrow. So with that being said, this is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. See you guys soon. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.